Dateline Arlington. Amidst multiple litigations in which the ever-interesting Major Mike Webb is currently involved, last week it was announced that his suit against the Arlington Public School Board, and other defendants, alleged to have engaged, individually, jointly or severally in a tortious interference with his electoral and public advocacy campaign to save the name of Washington Lee High School has been transferred to the Supreme Court of Virginia in Richmond. His initial petition is due on November 29, but is expected to be completed much sooner, permitting the defendants to provide a reply, but after release of audio recordings of the transcript from the lower court, any lover of individual liberty and democracy has to wonder what defense these defendants will be able to present for themselves. For instance, Virginia Supreme Court Rule 1.8 provides, in relevant part, that unless otherwise provided by order of the court in a particular case, any written motion for leave to file an amended pleading shall be accompanied by a properly executed proposed amended pleading, in a form suitable for filing. This rule specifically states that a proposed amended pleading must be attached to a motion, but bear witness to how the presiding judge, the Honorable Louise M. DiMatteo, acts as if the rule does not exist, rendering Major Mike Webb defenseless regarding a claim that he had filed an improper pleading. Discrimination, back and to the left. Moreover, even if a befuddled and ignorant defendant had not managed to file an amended pleading properly, for this worst-case scenario, under the same Rule 1.8, leave to amend shall be liberally granted in furtherance of the ends of justice. Yet, listen to the ruling of the court in its application of this liberal grant to Major Mike Webb. Discrimination, back and to the left.
I don't know, you all responded to the amended complaint, and without authorization from the court, technically an amended complaint's not permissible, so I don't know how you want to treat that, but that was my initial reaction to the whole thing, so maybe you can help me out with that.
We were confused by the filing, Your Honor. I think the amended complaint and the original complaint, our response would go to both. I don't believe that Mr. Webb had leave to file the amended complaint.
There's none in the file.
But to the extent that the court is treating it as filed, we would submit our response.
Well, I mean, people file things all the time with or without authority from the court, the question is whether you all waive authorization so you can get to this place. I don't know what you all want to do, but that would, just because people file it doesn't mean it's proper, nor does it mean you have to respond to it. But I don't know, you'll have to tell me what was served, what wasn't served, just so that I get the framework, because, I read the amended complaint. I didn't read the original complaint because that's not what the pleadings went to. So kind of a mishmash of things going on. And I understand, I've read it, so I understand the landscape a little bit, but just wanted to throw that out there.
We were served with both, Your Honor, and we are fine with if the court is granting him leave to file the amended complaint or have it deemed filed. We are prepared to proceed on that. I
ask you to do that because I wouldn't necessarily be inclined to do it because we haven't even had a ruling on the original complaint. But if you want me to have a concession on your part to deal with it, I can. I just want to make it clear. I'm not making an independent decision since it's not in front of me to allow an amended complaint. But if you want me to agree that you all permit the amendment and then address all of it, I can do that. But I just want you to understand where we are on that.
On behalf of the Carlton, I would consent to the court considering the amended complaint.
Okay.
Your Honor, I represent Arlington County. My name is Ryan Salmon. We haven't noticed our demurrer, but we were only served the original complaint, so I would object to the amended complaint.
Okay, so there's just a general procedural issue that is difficult to deal with right now. Why don't we just deal with the original complaint then? Is that how you want to do it?
And that's fine. Our pleading would remain the same, Your Honor.
Okay.
And I think the Carlton is probably the easiest party to dispose of. The issues raised by Mr. Webb have absolutely nothing to do with the Carlton. And as we contended in our pleadings, that they were merely filed to harass the condo. The condo had sued Mr. Webb in the General District Court.
Simply shocking. Simply shocking. Discrimination, back and to the left. Reviewing procedural events, we find that, at approximately 9 a.m., on July 6, 2018, Webb's original complaint was the first court challenge filed related to the name change at Washington Lee High School. Webb had been actively involved as an advocate for preserving the name of the high school from the beginning of the controversy, standing up an online petition on August 22, 2017 on change.org. And, attempting to exhaust all administrative remedies, he alerted both the superintendent, as well as the Washington Lee High School Parent Teachers Association of his intent to seek legal action on June 8, 2018, the day after the decision of the Arlington Public School Board. Later, on July 13, 2018, at 10:38 a.m., Webb filed a motion to amend the original complaint, along with a request for admissions from the Carlton Condominium Unit Owners Association, placing copies of both pleadings in the U.S. mail, as noted in the certificates of service to all of the named defendants. Unlike the original complaint, which is served by a professional process server, or, as in this case, uniformed officers from the Sheriff's Department, most other pleadings are governed by Virginia Supreme Court Rule 5.1d, which states, unless service or notice is otherwise specified in a given rule, any paper or object filed with this court must have included within it or appended to it a certificate of service or acceptance of service showing that a copy has been transmitted to all counsel and showing the date and manner of transmittal. That is it. Under the rule, a filer only provides an attestation, essentially on the honor system, that he provided a copy to the other parties in the suit. Nothing additional is filed with the court. However, listen here to the argument presented from John Cafferkey, a cum laude graduate of the distinguished Harvard Law School, and the expert attorney upon whom most every public school district in Northern Virginia relies. Discrimination, back and to the left.
Mr. Cafferkey, good morning.
Good morning, Your Honor. John Cafferkey, School Board Attorney for the Arlington County School Board, and I'm here on behalf of the school defendants who are Monique O'Grady, one of the school board members, one of the private school members, Linda Erdis, who's an assistant superintendent in charge of community relations, and what's described in the complaint and the amended complaint as Arlington County Public Schools, not actually a legal entity. The legal entity is the school board. And we're here on our motion to quash, or on the alternative for leave to file the demurrer and plea bar that we filed. And I will say that demurrer and plea and bar are addressed to the amended complaint, as I indicated, Your Honor, in the motion that we filed. I only discovered that this lawsuit was out there last Thursday afternoon. As it turned out, the plaintiff has a number of different claims against a number of different parties. One of them in this amended complaint has to do with his dissatisfaction with the board's decision to rename Washington Lee High School.
Right.
As it turns out there's one or two other people who are unhappy with that as well. There was another lawsuit that was received and served either on the same day or the day before. The secretaries who got these additional copies thought that they were just further copies of this. They weren't really in a position to have authorized to receive this process on behalf of Ms. O'Grady or the school board or Ms. Erdis. As I mentioned, is that when I started getting filings from these other defendants, or when they were forwarded to me, I went over. I thought it was sort of funny that we hadn't gotten any service copies of any against the school defendants. So I came over here last Thursday afternoon. To my surprise, found that there was a return of service for the school defendants. Immediately filed this motion, and have also filed a demurrer and plea and bar.
That was the amended.
And there to the amended complaint, we were not, to my knowledge, the school defendants were not served with the initial complaint that I think was filed back sometime.
Note how, after blaming some confusion on filings upon the staff for his client, the Arlington Public Schools, this attorney, John Cafferkey, just falsely represented to the court that either he is not familiar with Rule 5.1 that dictates that he would not have filed a return of service for the amended complaint. Discrimination, back and to the left. Just to be certain, let's listen to these words very carefully, again.
I indicated, Your Honor, in in the motion that we filed. I only discovered that this lawsuit was out there last Thursday afternoon. As it turned out, the plaintiff has a number of different claims against a number of different parties. One of them in this amended complaint has to do with his dissatisfaction with the board's decision to rename Washington Lee High School.
Right.
As it turns out there's one or two other people who are unhappy with that as well. There was another lawsuit that was received and served either on the same day or the day before. The secretaries who got these additional copies thought that they were just further copies of this. They weren't really in a position to have authorized to receive this process on behalf of Ms. O'Grady or the school board or Ms. Urdas. As I mentioned, is that when I started getting filings from these other defendants, or when they were forwarded to me, I went over. I thought it was sort of funny that we hadn't gotten any service copies of any against the school defendants. So I came over here last Thursday afternoon. To my surprise, found that there was a return of service for the school defendants. Immediately filed this motion, and have also filed a demurrer and plea and bar.
But that was the amended.
And there to the amended complaint, we were not, to my knowledge, the school defendants were not served with the initial complaint that I think was filed back sometime in...
Webb did not, at that time, schedule a hearing on the motion, and the court never approved the amended complaint, which was attached, in accordance with the applicable rule, with the proposed order to the motion. The only substantive change in the amended complaint was the identification of the Arlington County Democratic Party Committee, hereinafter the Arlington Democrats, as an additional defendant to the suit. Discrimination, back and to the left. No express reason has been articulated as to why the clerk of the court added the proposed amended complaint to the docket, or why she decided to provide a time-date stamp to the filed attachment, or why John Cafferkey, counsel for school board member Monique O'Grady, Assistant Superintendent Linda Erdos and the Arlington Public School Board claimed that they completed a return of service for an attachment sent as a part of a motion with a certificate of service, in accordance with Virginia Sup. C2 Rule 5.1, D, nor why the trial court quashed an amended complaint for which a hearing was never held. Discrimination, back and to the left. But, this assumption of ignorance of Major Mike Webb, an African American, not only appears to be unconscionably exploited in these judicial proceedings, but also in the pleading replies from the learned counsel. Discrimination, back and to the left. In their motion, Cafferkey, counsel for the Arlington Public School defendants, described the amended complaint that they claimed they received, and for which they, oblivious to the local court rules, they filed a return of service. Thusly, quote, the amended complaint includes a rambling assortment of grievances against various defendants including Arlington County, a condominium association, the Arlington County Democratic Party Committee, unnamed John Does, and 3 defendants associated with the Arlington County School Board, including school board member Monique O'Grady, Assistant Superintendent for School and Community Relations, Linda Erdos, and Arlington Public Schools. Unquote. Discrimination, back and to the left. Listen here, as, with short shrill shrift, the presiding judge, the Honorable Louise M. DiMatteo, treats Major Mike Webb disrespectfully, as an ignorant child, to quash an amended complaint that was refused recognition by the court, despite a rule that dictates liberal allowance, and how she simply indulges a Harvard attorney's ludicrous excuse that he never received a court document for which his client, the Arlington Public School Board, had signed for receipt. Discrimination, back and to the left.
What I can make short work of that. There's no authorization to file an amended complaint. I would quash service of the amended complaint. I mean, you can't just file amended complaints. You have to get leave of court. So where'd you get leave of court, Mr. Webb?
Your Honor, the amended Your Honor, the amended complaint was filed with a motion to...
You can't serve it. You file a motion to amend, but you can't serve an amended complaint. So the service is quashed. Yeah.
No, Your Honor, it was attached to, it was, I guess, there was a motion, and it was...
And I know you don't understand this process, and I appreciate that, but I'm going to quash the service of the amended complaint.
Oh, yes, Your Honor.
Reported to be service of the complaint, it's quashed.
Oh, yes, that's right.
Have a seat, Mr. Webb. All right,
Good, and I have an order, Your Honor.
so I'll make short work of that one. So in other words, you don't has the original complaint ever been served on you?
Not to my...
All right, and there's no motion pending today on a motion to amend, so that's not going to be heard today. So quash service, and Mr. Cafferty will take care of that order for me. And there's another motion, Mr. Cafferty, that you appear to have filed. I guess that's all it is, the motion to quash?
It was, Your Honor, was an alternative motion, and my sketch order here says that the motion for leave to file with demurrer and pleading bar is denied as moot.
Exactly. That's perfect. So is there anything else I need to take up on those motions for either?
Not for me, Your Honor.
Very good. All right. That takes care of it then. Thank you all.
Thank you.
And counsel and Mr. Webb, if you want to take a look at those orders outside and object or agree or however you want to do it, and then hand them back to me before you leave, I'll enter them. Thanks.
A 172837 Lodi Kaiser Foundation.
In its cover letter to Major Mike Webb, Marion Tadros, counsel from Reesbrook, PC, for the Carlton condominiums, took the liberty to include in exhibits their cover letter transmitting their reply to his complaint, which threatens, quote, "The association requests that you immediately dismiss the complaint against the association with prejudice," unquote, while mocking his complaint as both frivolous and possessing no legal or factual basis, themes repeated by the trial court. Discrimination, back and to the left.
For assessments due and owing, he filed a counterclaim. I appeared at a motion to dismiss the counterclaim. Mr. Webb could not find a single fact that would support a counterclaim against the association. The General District Court told him that it would sanction him in the future if he filed these pleadings. He had said, well, how am I supposed to know I'm not a lawyer? And the court said, well, if you're not a lawyer and you don't know it, then you shouldn't be filing it. Right. So we find ourselves here in the unfortunate position where the association is forced to incur fees. There's no basis for any of the relief which Mr. Webb seeks in either the original complaint or the amended complaint. And reading them, I can't tell what he's asking for at all. And that is the problem when an entity has to deal with these types of cases that Anderson versus Sharma addresses, where if he intends to keep filing these things, we would request that, at least on behalf of the association, Mr. Webb seeks leave of court in order to make these filings. Otherwise, the association is forced to incur fees. Right. To the extent that the court is inclined to grant sanctions, I would request that we have a separate hearing on that. I did not think we would be able to address the issue of fees, so if the court grants sanctions today, I would ask that it be bifurcated so we can have evidence on the amount of fees incurred by the Carlton to date.
All right. So let's take this up one at a time. There's a complaint and petition for a temporary injunction that's been filed as the original complaint. It looks to be substantially similar to the amended complaint. Specifically, and I'm going to address this to Mr. Webb, so you can have a seat, ma'am. Mr. Webb, if you come to the podium, I'm just going to ask you a few very pointed questions, since we understand what the landscape is here. What are the specific allegations factually that you have against the condominium itself that are in your complaint?
That's right.
What are they?
Okay.
Listen here, as, with short shrill shrift, the presiding judge, the Honorable Louise M. DiMatteo, treats Major Mike Webb disrespectfully, as an ignorant child, to dismiss his complaint, and issue restraints upon his judicial rights. Discrimination, back and to the left.
Again, it's a big tortious interference with his expectancy claim.
You need to answer the question very specifically.
Yeah, but I was trying to frame in terms of the facts, Your Honor.
I saw the complaint. I don't need to have it framed.
Oh, yeah, yes, Your Honor.
Specific allegations, because I couldn't figure it out.
Exactly.
What is the complaint against the condominium?
That actually about less than 2 weeks prior to the election, I was brought into a suit, sworn to be in New Jersey.
I understand. I read that part.
Yes,
Okay,
Your
so
Honor.
that's the issue. The issue is you're claiming that they sued you with a false affidavit in order to undermine your ability to run for school board
Yes.
and have a legitimate candidacy because it's undermined your reputation somehow?
Yes, Your Honor.
And it's tortious interference with your business? Is that the allegation?
Business expectancy, yes.
All right, business expectancy. All right. Mr. Webb, that is not what that claim is. So the claim against this, even assuming that factually true, reasonably extrapolated from what you filed, is not a cause of action against the conduct, okay? It's just not a claim, okay? And you've repeated that claim in the amended complaint. So what I can find today is that, one, the demurrer should be sustained, because there's no cause of action against this defendant, and two, that no amended complaint shall be and can be filed against this defendant because you filed an amended complaint, and it states the same inappropriate request, okay? So no additional complaint may be filed against the condominium, okay? So that's number one. On the issue of sanctions, I'm not inclined to grant sanctions under the circumstances. Monetary damages, that's what's being requested. However, as a sanction, since I've already denied any additional relief in this lawsuit, in an effort to prevent Mr. Webb from filing additional lawsuits that are of this type, meaning they don't have a basis in fact or law, I will require that if Mr. Webb wants to file any additional claims against this defendant, so it's only your case, right, that they need to be, approval needs to be given by the court, okay? So that's what you would have to do first to get permission to file. So I'm agreeable to that, and I will treat that essentially as the sanction in this case because it has a bit of a history, okay? So that's the Carlton's case. All right, so Mr. Webb, you can have a seat.
It is often said in the law that due process is the process that is due, but, amazingly, you will never find those words in any state or federal court case because it is a concept derived from a 1960 U.S. Supreme Court decision, Hannah v. Lark, 363 U.S. 420, and it is a phrase that only appears in administrative law proceedings, and not by any court. The exact case is Secretary of Labor vs. TP Mining Incorporated, 8 FMSHRC 687, where it states, due process is the process that is due under particular circumstances and does not invariably mandate trial-type proceedings. Yet, the transcripts of hearing, totaling under 25 minutes, but demonstrating a silencing and ridicule of one litigant, and disparate treatment to others arguing their cases, compel a conclusion that a violation of due process occurred. But, pleading with particularity and eschewing wild speculation, what animus, vindictive enough to suggest financial sanctions and impart curbing of judicial rights, underlies these conspicuous actions of both esteemed counsel and an honorable court? That is a matter for the Virginia Supreme Court at this report, less than 2 weeks before the critical midterm elections. Discrimination, back and to the left. And, as noted in our last report, Mr. Cafferkey and his Arlington Public School Board clients have far greater concerns at the present, even more pressing than preparing a reply to a petition for appeal at the Virginia Supreme Court, because, by accepting Arlington Public School Board member as inclined to defend claims alleged in a complaint not regarding her activities as an elected school board member, but as a candidate for that office, maximum criminal penalties of up to 20 years in prison can be handed down to O'Grady and members of the board for violation of Virginia Code Section 19.2 to 217, while Mr. Cafferkey is potentially liable not just for knowing receipt of these inappropriate funds, but also charges of perjury, including the filing or arguing of false statements to a court, which is punishable by imprisonment from 1 to 10 years, confinement in jail for up to 12 months, and or a fine of up to $2,500 under Virginia Code Sections 18.2-434 and 8.01-4.3. Discrimination, back and to the left. Complicating matters even further for the Arlington Public School Board is that the confessed non-attorney Major Mike Webb has announced plans to file an action under the Declaratory Judgments Act to render the Washington Lee High School Renaming Committee Policy Implementation Plan unconstitutional, as applied. Webb has a strong case for this as applied challenge under the 14th Amendment because, first, not only has the County of Arlington had a long history of adverse impact upon African American Americans with regard to public education, but they have essentially self-designated themselves as attempting to address this bitter history by the cosmetic change of the name of a local high school. Unlike the matter before the U.S. Supreme Court in Parents Involved in Community School versus Seattle School District No. 1, 551 U.S. 701, 2007, where Seattle schools had never been subjected to desegregation decrees, the present matter presents an issue raised by the proponents of the name change. Remedying the effects of past intentional discrimination is a compelling interest under the strict scrutiny test, and that interest is involved here because the Arlington schools were segregated by law and subject to court-ordered desegregation. Discrimination, back and to the left. Under this legal analysis, applying strict scrutiny because of the presence of racial animosity as a potential motivation, the burden of proof shifts to the defendant to rebut the presumption of discrimination by producing a legitimate, non-discriminatory reason for his action. Then the presumption raised by the prima facie case is rebutted and drops from the case. And the defendant must then show that the articulated non-discriminatory reason is merely a pretext. John B. Potter, 369 Federal Supplement 2nd 763, Eastern District, Virginia 2005. Discrimination, back and to the left. Similarly stated, under the rule, with a prima facie case made out, the burden of proof shifts to the state to rebut the presumption of unconstitutional action by showing that permissible racially neutral selection criteria and procedures have produced the monochromatic result. Citations omitted. Washington v. Davis, 426 U.S. 229, 1976. Discrimination, back and to the left. As Dr. Martin Luther King, Jr. stated, injustice anywhere threatens justice everywhere. Coffee is for closers. Attention. Interest. Decision. Action. Do I have your attention? I know that you are interested. Have you made your decision for Christ? Now is the time for action. But you have the right to remain silent. Stay tuned for updates as they develop. We get the news as it happens and we get it to you before anyone else. Back to you, in the studio, Mo.
Say goodnight, crazy.
Back to you, in the studio, Mo.
Say goodnight, crazy.
Back to you, in the studio, Mo.
Say goodnight, crazy.
Back to you, in the studio, Mo. else. Back to you, in the studio, Mo.
Say goodnight, crazy.
Back to you, in the studio, Mo.
Say goodnight, crazy.
This advertisement was authorized by Mike Webb.